Hello and welcome, everyone. My name is Brian Walker, and I'm thrilled to be your narrator for today's highly anticipated live stream event. We're broadcasting to you from the offices of Global Talent Immigration Law Group, and we've got an exciting and informative session lined up for you. Today, we're honored to have with us two distinguished experts in the field of immigration law. First up, we have Liz Profumo, the managing attorney at Global Talent Immigration Law Group. Liz brings a wealth of experience and knowledge to the table, and she's here to shed light on some of the most complex aspects of U.S. immigration. Joining her is Jordana Schwartz-Matricardi, an accomplished attorney at law who specializes in helping talented individuals navigate the intricacies of immigration law. Together, they make a formidable team, and we're lucky to have them here to answer your burning questions. Now, here's the exciting part. This isn't just a one-way conversation. We want to hear from you. Throughout the live stream, we'll be accepting questions via chat. Plus, we'll be addressing questions that were submitted in advance by our audience. So if you've got questions about O-1 visas, EB-1 green cards, or anything related to extraordinary ability immigration, you're in the right place. So without further ado, let's dive right in and get the conversation started. Liz, Jordana, the floor is yours.
Good afternoon. So let's get right into it. Liz, Nicola from Australia has a question. Have you done any visas for influencers?
Oh, Nicola, what a great question. Actually, yes. In recent years, we have done many visas for influencers and actually content producers as well. You know, I think that in general, the paradigm's really shifting away from traditional modeling as well as film and TV, and definitely going towards, more social media content. So yes. And actually, I think on our website, there is also some information about doing O1s for influencers as well that you can check out.
Have you done any visas for a teen actor? Does being under 18 make the visa process harder?
So we certainly have done O1s for minors. Let's see. So does being under 18 make the process harder? So the legal standard is the same. The evidence the government looks for is the same. Obviously the challenge for younger artists is just that they often haven't had the opportunity to do enough work to qualify. But, any young actors that have had big roles in maybe 4 or 5 productions or projects certainly could be candidates for an O1.
Okay. Domenica from Australia has a couple questions. The first one, are the requirements for an actor O1 visa the same for a child as for an adult? If not, how does it vary?
Okay, well, so similar to the last question. So it is the same legal standard. It's the same kind of evidence. So really there isn't a legal difference between the O1 for the adult or for a minor.
Okay. And Domenica's second question, is there anything that I may be required to provide as a parent of an O1 child applicant?
Another really good question. So, I mean, of course, in terms of putting together an O1 visa application, oftentimes the parents are very involved in terms of the document collection, but also from a nuts and bolts level, a lot of times minors are not allowed on set without a parent or guardian present. And for that reason, sometimes parents will obtain an O2 visa in order to be able to stay in the U.S. for an extended period of time and support their children on set.
Okay. So we have a question from Suki in the United Kingdom. And hi, Suki.
Hi, Suki.
And she asks, if we're waiting for our embassy interview, will our approved visa petition eventually expire? How long do we have to book the interview?
Okay, great question. So when someone applies for an O1, it's a 2-step process. First, we file a petition in the US that has to be approved. And then after that's approved, for anyone who's abroad, they have to attend a consular interview, or these days make arrangements to mail passports in to have the visas issued. So the first question will your petition expire? And the answer is no. So when you file a petition, it's valid. You ask for a start and end date, which is usually 3 years, which is the maximum time. And so during that 3-year period, the petition does not expire. Now, for the second part, in terms of the consular interview, there is an application, a DS-160 application that is submitted in order to schedule the consular interview and apply for the visa at the consulate. From the time that's submitted, that usually remains valid for a year.
Okay. And Suki also asks, is there anything we can do to speed up the visa process during the actor strike? One of my deal memos is a non-union, and I'm worried I'm losing work.
Yeah. So, I haven't been able to get very clear guidance on this point, and I'm getting mixed stories from my colleagues in terms of whether consulates are issuing visas for actors during the strike. So, the rule is that during the strike, that if productions have secured what's referred to as interim agreements with the Screen Actors Guild, that those productions are allowed to proceed. In order for the productions to secure those interim agreements, the producers are required to provide extensive documentation and information about the productions. So when that's, if that's not available from the productions, then those agreements won't be available. So if those agreements are in place and you have proof of that, then I think that it is okay to attend the interview with the proof that those projects are allowed to proceed. Without that, I'm not certain if the consulates will be issuing the visas to work, on film projects in the US until the strike ends, unfortunately.
Okay. I'm actually going to take a question from the chat. This one is from Piero. He's asking, for the EB1, should the criteria you present to the examiners only be the ones that you can make a strong case for, or should you also include evidence supporting other criteria, even if it's not as strong?
Very good question. And I think that different attorneys that do this kind of work are going to have different answers for this question. So there's a couple things. So from what I've seen over the years is that sometimes arguments that I think are not very strong arguments are the arguments that USCIS thinks are the better arguments. So, so my answer personally would be that if there are arguments that are passable, look, you don't want to make very weak arguments, in my opinion, but if there are arguments that you've seen work in the past, I think it is worth it to include them because you don't know what USCIS is going to say. What I mean by that is, maybe we'll argue 6 criteria of an EB1, and the argument that I put at the end that I think is the worst, if USCIS issues a request for evidence, that might be the only category that they agree that we've met. So I think you want to make whatever arguments you can in the initial filing. And then if they issue a request for evidence where you have to really defend your arguments, at that point, you might want to focus on the stronger ones.
Okay. I'm going to shift back to the O1, and this question is from Ha Young Park in Los Angeles. Ha Young asks, where can I find a management organization? And I think that's in reference to the advisory opinion.
I think you're right. So for anyone who works in the film and TV industry and applies for an O1 visa, whichever union oversees your field has to look at the case and issue a letter stating they have no objection to you working in the US. If there is a labor management organization that oversees the field, which is almost all the time in film and TV, it's the AMPTP, the Alliance of Motion Picture and Television Producers. So, if you're working in film and TV, that's going to be the management organization. But also that is a step that, that we take care of as legal counsel and that most attorneys will handle for you. If you're applying for an O1, it would be unusual for you to obtain your own management organization letter.
And the second question, how to prepare evidentiary documents for the O1?
Oh, okay. So, actually, the O1 visa requires a lot of supporting evidence. You know, we have to show USCIS, depending on what type of O1 you're applying for, whether it's in business, science, education, athletics, or whether it's on the art side with more film and TV. you know, Either way, you need to make sure, your attorneys, if you work with us, will certainly advise you on the forms and the formats of all the documents and the evidence to let you know if it's appropriate. Um, any press that's written about you, that's going to be included, in all kinds of O1 cases. Almost all cases are going to include letters of recommendation from industry experts, though they might attest to a different points. If you've won awards in your field, you'll want, proof from the organizations. I don't know that I want to go into all the documents that go into an O1. Anyone who does want to have that conversation, please feel free to go to our website and schedule a consultation. But we would be able to certainly advise on all the documentation that goes into an application.
Okay. All right, Marina from Brazil, she asks, what media publications and how many are necessary and sufficient to meet the criteria for the EB1 green card?
So, the government actually doesn't say how many publications are required. They say that they're looking for publications, major publications, trade publications. They specify different types, there are different adjectives for what kind of publications they look for different criteria. From my experience, I generally, depending on whether you're a behind the scenes person or an out front public person, I would say I personally tend to like a minimum of 4 or 5. The bigger the publication, the better. The more prestigious the publication, the better. Because these days, just providing circulation information or how many people read the publication may not be sufficient anymore. In addition to that, they actually want information about the publication, about its history, about the success of the publication. So,
And just to piggyback on that, how about things like interviews on the news or podcasts?
Yeah, so both, yes. So USCIS at this point only looks at paper. So if we send a link to a video or a podcast, they are not going to listen to it. So what you have to do is provide a transcript of any interviews that are televised or podcasts. Now, for both of those, though, you have to show again, and especially for podcasts, that it is considered a major media source. There are a lot of podcasts these days, and there might not be good background information available about the podcast to show what makes it major or distinguished. So you want to be able to still provide that information for those formats as well.
Okay. And Marina has a second question. Do I need to continue working in my country at the time of filing the petition? Does the officer notice that I continue to work in the same field?
So there is not a process where they're going to check that. So I suppose, I mentioned earlier that we file first a petition in the US, and then for anyone abroad, they have to go to an embassy appointment. When you go to the embassy appointment, they'll ask you about your current employment, but I've never heard of someone being penalized for being unemployed at that time or working at a different job. Now, often for creatives and artists, they're self-employed. And so listing that as a profession at the time that you fill out the DS-160 is common as well, in my experience.
Okay. I'm going to go back to the chat. I have a question from Andy. This question is about a minor O1 visa, but I guess it probably applies to any applicants. How many letters of recommendation are needed, and how far in advance is it possible to start collecting them i.e., do they have an expiration date?
So letters of recommendation do not have an expiration date. Generally, as a rule of thumb, I personally like to make sure that, so I certainly will use letters that have been written in years past, but I want to make sure that there is new evidence in addition to previously used ones, but they don't expire. In terms of the number, again, USCIS doesn't set the number. They don't say how many letters of recommendation they're looking for. I personally definitely believe in quality over quantity. And so normally I only do 4, 5 letters of recommendation. And I know that might be controversial. I talk to people that say, oh, the last time I did an O1, my attorney included 10 letters and 12 letters and 15 letters. But from my experience, there's not a benefit in providing that many additional.
Yeah, agreed. Andy also asks if there's a template to follow.
So there's not a template because the letters for O1s are, in order to have the most impact, they're going to be very personalized and tailored to the person who's writing them and what their personal experience is with the artist. So for that reason, I think it's going to be challenging to use a template. There might be certain points that you want those letters to cover, but a template wouldn't really necessarily, be sufficient.
Okay. I'm going to go back to.
And I'm sorry. Can I just make one more point? The letters of recommendation, when done properly, can actually be used to meet, to strengthen arguments for several of the O1 criteria. So we prefer to write the letters. Actually, we insist on writing the letters to the extent possible in order to make sure that they include all the right language and hit all the points so they have the maximum impact in each case.
Okay. And my next question comes from Aurora in Australia. And Aurora says, I am a child, 13. Is it best for me to work towards my visa and then just travel over as jobs come up? Or should I be looking at moving to America to make the most out of it when I get it?
Ooh, Aurora, you're thinking about such big things at 13. Wow. Let's see. It's such a personal decision that's going to have so many factors involved. I mean, of course, working in film and TV, I'm assuming it's film and TV. I don't know what your background is. But that's one component, but that doesn't take into account, your family, your education, and all those things. The O1 is not really the best visa to hold to be a full-time student. So, it's a big decision to come and relocate and move to the US before your education is complete. So I can't really give you tell you which answer is right for you. I've seen people go both ways. But if you want to, if you want to schedule a time to talk, if you and your parents want to schedule a time, please just reach out through our website and I'm happy to talk to you about your situation.
And the second part of her question, is it better to prepare and work towards getting and paying for the visa yourself, or get everything you need to get the visa and wait for the job to come so they will pay for it and organize it? I think what she's asking is the employer
right.
will pay for it.
Yeah, I totally understand. So again, very, very personal decision, because on one hand, of course, it's wonderful when the employer pays for it and takes care of all the paperwork. Huge benefits to that. But then, of course, the downside is you're on the employer's timeline and, you're kind of at their mercy. Whereas, if there are other projects that you're working on, but those companies might not be, offering to pay for the visa and you're willing to pay for it yourself, you might be able to have more control over your timeline.
Okay. I'm going to go back to the chat, and there is a question from Ruby, And Ruby asks, how to find evidence of comparable salary information if there is no SOC code for a job role? This is for the high salary EB1A criteria.
Oh, Ruby, what a good question. It sounds like you're really in the weeds on this. So, Ruby, you have correctly identified that USCIS is very, very tough on high salary. From what I'm seeing, they want to see that the only type of evidence that they are certain to accept is proof that you are a W-2 employee and you have a tax return with a W-2 showing that you earn a high salary, let's say, top 10% of people who do, in your profession across the country. And so many of our clients, are not W-2 employees. They're creatives. They have 1099s. They work for various companies. And honestly, USCIS is difficult to show USCIS that you meet the high salary requirement as an independent contractor. So I actually don't have a magic answer. Depending on what your profession is, you can do the research to see what kind of, if there's any authoritative sources that publish about wages for independent contractors for your field. That's always the best. In the absence of that, you can try to find comparable job postings in your area and show how much those positions are paying. But to be honest, to get USCIS to accept that kind of evidence of like comparable job postings, I think is going to be an uphill battle.
Okay.
It's a battle that we deal with routinely. So feel your pain on that one.
Certainly. And let's see. Dara from Germany. Actually, my O1 ends in 2 years from now, but I quit working with my sponsor company and I am back in Germany now. Do I have to find another sponsor and apply all over again?
So, yes. So if you're no longer working with the company who petitioned for your visa, then you do have to file a new petition to work with either another company, or depending on your circumstances, if you have what's called an agent petition, a new agent may need to file a petition for you. So yes, a new case needs to be filed. However, the good news is you can still use all the evidence and all the documents that you used to show you were extraordinary in that first application. So of course, you'll have to show new, information about the new work you'll be doing, but you can, reuse the documents you have to prove your extraordinary ability.
And Dara also asks if she needs new advisory letters because her letters are just 1 year old.
So it depends on what you do, which organizations issued the letters. Some organizations, especially in film and TV, are very specific to both the petitioner and the specific projects that are included in the initial submission, and the advisory opinions are just limited to those projects. Other unions or peer organizations are more broad and might not have that specific language. So we'd have to take a look to see, we'd need a little more information. But if you're working in film and TV, I would say it's likely you would need new advisory opinion letters to work on new projects.
Okay. I'm going to go back to the chat, and I have a question here from Rachel Wool. Shout out, Rachel. Love this. What's the current wait time for normal processing that you're seeing?
So, Rachel, you've probably seen that recently USCIS has changed the rules for filing O1 petitions. For many, many years, they were filed either at a service center on the East Coast or West Coast, and each one had their own processing time. And recently, they switched all filings to a centralized service center in Texas. So we've been waiting to see what USCIS is going to do with processing. From what we've been seeing, they're basically just transferring the cases back to the service centers where we were filing them prior to October 1st. So I think that the processing is going to be the same as it was prior to this recent change, which my best estimate, I can't be officially held to this, would be more like 2 to 3 months on the East Coast and more like 5 to 6 months on the West Coast.
Okay. So I have another question here. What evidence do I need to show to prove my leading role on projects for the O1 visa?
Very good question. For me personally, my favorite evidence tends to be press. If there's press talking about your role with an organization, that's fantastic. That's going to be USCIS loves press talking about you. Another way, the most common way, I would say, is through a letter of support from a supervisor, an executive, or someone that has direct personal knowledge of your role within a company or organization. If you have a contract that shows that you're very well compensated for your work, there can be an inference that your role there is an important role. I don't know. What am I forgetting? Is there anything else?
No, I think, did you mention contracts, deal memos? Yeah, I think you
hit it?
hit them
Okay.
all. Okay, so we're coming down to our last couple questions. So if anyone has anything pressing, please go ahead and write it into the chat. Until then, I'm going to ask one more from the pre-sent questions. And the next one would be, can anyone from any country apply for the O1B or EB1?
Yes, there is no limitation on the citizenship or nationality of applicants for O1s and EB1s. Again, in the second part of the process, for anyone who's outside the US, there is a consular interview. The consular interview process, from my experience, may be more challenging for citizens of some countries than others. For the majority of applicants around the world, it's, the consular interviews are not terribly challenging. However, there certainly are exceptions.
Okay. And we're going to take our last question now. Before we do that, if anyone has additional questions that we did not get to or would like to schedule a consultation, please go to our website and you can do that. You can schedule a free consultation there. And the last question I have is from Andy. And she asks, again, with regards to letters of recommendation for actors, can those letters come from both theater and film TV experts in the field?
Oh, that's a really, really good question. So, there is an O1 visa that's for arts, and then there's another separate set of regulations for O1 visas for people who work in film and TV. I would say that for the first 10 years, I was, 10, 12 years, I was working on O1s. We would combine film and TV credits with stage credits, and it was never an issue. Then USCIS started a trend where they said, look, there are different regulations for both of these sections. So tell us, is your case in film and TV or arts? And we're based in Los Angeles, and almost all the clients that we see are interested in working primarily in the film and TV industry. And what we find is that if you're approved to work in film and TV, that I've never heard of a theater company that will turn you down because your visa is approved to work in film and TV. However, the opposite's not always true. So if you have a visa that allows you to work on stage, that the more sophisticated production companies or the networks or studios, they will not accept an O1 visa to work on stage to allow you to work in film and TV productions. So we would always, focus all the evidence on the film and TV. So I think it was last year, USCIS actually issued guidance about this and said, look, for people who are working in film and TV as well as the arts, that's okay, but the case will be held to a higher standard of film and TV. So the way that I interpret that is yes, if you're going to be working on stage and you have offers to work on stage, you can include them. But the evidence is still your case is going to have a better chance of approval without an RFE if most of the evidence is especially the press, is more heavily focused on your film and TV work.
Okay. Well, that brings us to the end of our live stream. Did you want to say anything before we sign off?
I just wanted to thank everyone who tuned in to watch us. And if anyone has outstanding questions, like I said, please go to our website and schedule a consultation.
Thank you.
Wow, what an enlightening discussion we've had today. A big thank you to Liz Profumo and Jordana Schwartz-Matricardi for their invaluable insights into the world of extraordinary ability visas. And of course, thank you to all of you for tuning in and contributing your thoughtful questions. If you found today's session helpful, don't let the conversation end here. We invite you to stay connected with us on our various social media platforms. You can find us on Instagram at instagram.com/globaltalentimmigration, on Facebook at facebook.com/globaltalentlaw, and on Twitter at twitter.com/globaltalentlaw. We're also on TikTok. Just search for @globaltalentlaw. For more resources and updates, be sure to visit our website at globaltalentlaw.com. Once again, thank you for joining us today. We look forward to seeing you at our next live stream event. Until then, take care and have a great day.